to the candidate. Now, this notice of hearing was for March 25th, and of course, that hearing date was vacated due to the excusal of a judge, or recusal, I'm sorry, of a judge. So once the judge recused, I got the case, and this court set a new date for today, and there's been no evidence presented that the notice of today's hearing was presented, attempted to be served by the plaintiff pursuant to Rule 4.1a. The testimony of Mr. Keegan was that he never took steps to deliver pursuant to Rule 14F1A, a copy of the subsequent notice of hearing. So I can't say actual delivery was made. Now, while I took a break back there, I looked at the case, the only New Mexico case that seems to be on point. It gives a little bit of guidance to the court, and that's Charlie versus Johnson, 210 New Mexico Supreme Court, page 24. The case law seems to indicate that only an attempt must be made. The plaintiff in Charlie versus Johnson argued that he couldn't serve the respondent, the person he was challenging, because he didn't have a good address. He couldn't find the respondent. But apparently, the plaintiff in that case, Charlie versus Johnson, didn't even try to serve or deliver the required documents to the respondent. And the court said in the Supreme Court decision that the plaintiff must try to notify the affected candidate as soon as possible. And it further goes on to say, the plaintiffs did not even attempt to locate Johnson. In the absence of such an attempt, plaintiff's challenge to the adequacy of Johnson's address cannot be sustained. We cannot overstate the importance of plaintiffs at least trying to give notice directly to Johnson as soon as possible, so that he may have begun to prepare his case. So the argument, I don't think the argument can be had that failure to deliver pursuant to Rule 4 in and of itself is fatal to a plaintiff. But the plaintiff must try to effect delivery pursuant to Rule 4. Rule 4 says he will serve the person personally, or if the individual refuses to accept service, by leaving the process at the location where the individual has been found. The court finds the plaintiff was not able to serve the defendant personally. The court finds the plaintiff, or that the respondent did not refuse service. The court finds the respondent was not found at her location. She was not found by Mr. Keegan. If she would have been at the address in Crown Point where Mr. Keegan King went. And then Mr. Keegan King could have, let's see, left the documents there, and he would have been required to mail her a backup copy of the process as required by Rule 148. None of those things were done. So the question becomes, in this court's mind, did Mr. Keegan King reasonably try to serve her pursuant, or deliver pursuant to Rule 4? And I think there's a big distinction to be made between delivery and service. I mean, we're getting a little complicated here, but the court seeks to have a plaintiff attempt delivery. And that seems to be what the court, is all that the court requires, is to make a good, valid attempt. And why is that versus service of process, perhaps argued by the defense that it should be served versus delivered? And I think the delivery reason is that people will seek to hide out. People may certainly seek to avoid service of process. And that may be the case here. Miss Jeff hasn't been found since March 20th, when this complaint was filed. And I think the court could infer, I think the court in that drafting Rule 96 took into consideration a possibility and said the plaintiff's got to attempt to deliver, not serve or deliver. There's a distinction there because delivery is less than service. In my mind, there has to be a reason for the distinction in the language of the rule between delivery and service. And I think delivery is less than actual service. The plaintiff must attempt delivery. But then we go back, and the plaintiff didn't attempt delivery on Miss Jeff with the copy of today's notice of hearing. You never went back after your attempted delivery on the 21st. And I have to also conclude that the Secretary of State failed in her attempt to serve the respondent with notice of this lawsuit. The undisputed testimony on that is that the Secretary of State sent the mail out on the 28th after she got delivery of the lawsuit on or about the 21st. And the law requires under, I think it's the statute on this one, 1835B, the Secretary of State shall immediately, upon receipt of process, serve on the proper filing officer. That officer shall, by certified mail the process to the person.
Did you get permission to use that? No, I don't.
7 days after getting